Yes, the new law is wonderful in the sense that it allows the conviction of all levels of crimes to be expunged and get the full expungement under the statute, meaning your criminal records held at the courthouse as well as the BCA will be sealed. Now, level misdemeanors, gross misdemeanors, and felonies, certain low-level nonviolent felonies, are eligible for an expungement. The petitioner must demonstrate to the court and carry the burden of proof by proving by clear and convincing evidence that the benefit to them in getting the expungement is equal to the burden to the state. There are different waiting periods that apply, though. For a misdemeanor, there's a 2-year waiting period after you're done with your sentence before you can apply for an expungement. You have to be crime-free during that waiting period. For gross misdemeanors, it's a 4-year waiting period, and for felonies, it's a 5-year waiting period. An expungement automatically will take 4 months due to 2 different 60-day waiting periods at the front end and the back end of the expungement process. At the front end, after you file the petition, the hearing cannot be held at least for 60 days. And then after the judge issues an order, it's another 60 days before that order becomes effective. So right off the bat, you have 120 days that the expungement process will take. After factoring in time to prepare the petition paperwork and for the judge to make his or her decision, you should game plan for at least 5 to 6 months. Well, the new law lists out 12 factors that the court is going to be looking at when analyzing your case. Now, none of those factors are highlighted in the statute as being more important than the others, but of course old habits die hard. And based upon previous interpretations of the expungement law, I anticipate the court will look at certain factors more heavily than others. First, the court will want to see that you've suffered a burden or detriment as a result of your criminal record. Typically, this is shown by not being able to get employment, housing, professional license, even schooling, because of your criminal record. If you can have letters of denial, that goes a long way in demonstrating this. The court likes to see a history of this, if at all possible, too. Secondly, the court will look at your rehabilitation efforts. This can be a matter of going and getting professional treatment, programming to handle some type of chemical dependency issue if that's the case. The court looks at other ways that you've rehabilitated yourself. Maybe the petitioner has become more of a family person, been more involved in the community, involved in the church. It really can be a creative opportunity for the petitioner to demonstrate to the court why you deserve this and why you're a good person. I think of it as almost like your resume to the court, highlighting the best attributes about you and why you deserve to get the second chance. In addition to those factors, the court will look at your employment record, your criminal record as a whole, and the court will now look at the actual facts of the underlying crime at issue, determine the seriousness of it, as well as if there's any aggravating or mitigating factors from it. No, you do not, but it's highly recommended. The way I like to think about it is an analogy. If you give me and a chef the same ingredients and even the same recipe, I can guarantee you that that chef's meal will be substantially better than mine. If you give me the same facts and circumstances for an expungement, I can pretty much guarantee that the petition paperwork that I will submit and the argument that I can make at the oral hearing will be significantly better than a person without an attorney. I've studied in this. I follow the new law and the changes and how the courts are interpreting it, and I know what to say and how to make the arguments in order for you to present the best argument.